Good afternoon and welcome back to the McKercher Lecture Series. Part of the speakers series today is the third in our threesome of presentations, and today a panel addressing the UN Declaration of the Rights of Indigenous People and its significance in Canada for people of Indigenous ancestry and Indigenous governments and non-Indigenous Canadians as well. I will leave it to my colleague, Professor Jamie Lavallee, to introduce the panel of distinguished speakers we have for you today. But I do want to make two acknowledgements. The first, to acknowledge that as we gather here today, we acknowledge we are on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. I think a special acknowledgement as we discuss the issues of UNDRIP and reconciliation with Indigenous people this afternoon. Secondly, I'd like to extend my thanks and the thanks of the College of Law to the McKercher Law Firm for their continuing support of this McKercher Speaker Series. The UNDRIP sessions are one part of a continuing year-long series. The McKercher Law Firm has made a commitment to enable us to have multi-year support for these speaker series, nearly always on Mondays. And thank you, as I say, to them for that generous support. I'll now turn it over, if I may, to Professor Lavallee to introduce the panel. She will moderate the panel. It's all yours, Jamie.
Thank you, Brent. I'd like to welcome the people that are attending, as well as a great big welcome to our panelists, Drew Lafond, Professor Dwight Newman, and Corin Lightning Earl. The setup for today will be that Drew Lafond will speak, Dr. Newman, and then Corin Lightning Earl will also talk. And the idea is that this is a panel discussion, so that will be the main goal and focus. I believe Drew, Dwight, and Corin will present to a certain extent their perspectives and views on what Brent has put forward with regards to UNDRIP and its application within Canada vis-a-vis like the Bill C-15 that has passed. And then we will also open it up to questions from the audience. So please put your questions into the chat, and after going through our panel, we will circle back and bring forward the questions that have been brought forward by the audience, and then we will, as well as the fact that just in case, and question prompts are always a good idea as a professor. We also have a couple other questions that we have in case you as the audience is a little shy. So without further ado, I will. What I'll do is I'll briefly go over the biography of our panelists, so that way we don't interrupt it too much when they're about to present. So Drew Lafond is a partner at MLT Aikens. He advises clients on matters related to economic development, gaming, housing, commercial leasing, corporate governance, and structure and finance. He has worked in nearly all aspects of the commercial side of cannabis, including incorporating and organizing licensed producers under the medical and recreational regimes, setting up licensed retailers in Alberta and Saskatchewan, and advising on the processes of considerations required to regulate on reserve cannabis. He is also a citizen of the Muskeg Lake Cree Nation and was raised in Treaty 6, and he is also of Shuswap descent from British Columbia. Dr. Dwight Newman is a professor and a Canada Research Chair in Indigenous Rights and in Constitutional and International Law here at USask, at USask Law. He has taught during, Dwight's biography is a little bit longer, so I'm hoping to just take little pieces. But let's see, I was What do you want to do? Okay, prior to entering a faculty role, Dr. Newman clerked for the Chief Justice Lemire and Justice LaBelle at the Supreme Court of Canada, worked for non-governmental organizations in South Africa and Hong Kong, and for the Canadian Department of Justice. He completed his graduate studies at Oxford University, where he studied as a Rhodes Scholar. He has lived in half a dozen countries and has traveled to over 70 of them. He is a member of the Ontario and Saskatchewan bars, and he does selective legal work for industry, government, and Indigenous communities, focused mainly on constitutional issues associated with resource development, as well as consulting work on related issues for international investment entities. And then Korean Lightning Earl is at the Makoto Law and Governance Lodge at the University of Alberta. And let's see, what are part of it? She is a graduate of the University of Alberta and is a member when was called to the bar in 2009. And she had her call on reserve at Samson Cree Nation, which I believe that's also your nation. Are you a Samson? So Corinne is also from Samson Cree Nation. Her concentration during school was alternative dispute resolution, and she focuses on working with Indigenous clients and supporting the revitalization of Indigenous laws. She advises in the areas of Indigenous governance, Indigenous child welfare, Indian Act, and she is also an accomplished speaker on Indigenous cultural awareness and relationship building. She was awarded Tomorrow's Leader from the Women in Law Leadership Awards in 2019, and she is currently a sessional lecturer at the Muscatine Cultural College and the University of Alberta Faculty of Law. So welcome, panelists. And like I said before, we'll go with Drew, Dwight, and then Corin. Thank you.
Thank you for that introduction, Jamie. Can everybody hear me?
Yes, yes.
Excellent. Okay, thank you very much. Mitone miokeksepa yao. Kakiao, skumtano nitsone kegwa netotmak. My name is Drew Lafond. So Drew Lafond is Sigasun. I'm as indicated by Jamie, a member of the Muskeg Lake Cree Nation, also a descendant of the Secwepemc people in near Kamloops. Grew up, I was born and raised on the Muskeg Lake Cree Nation Reserve. Did my law school out at the University of Victoria, worked as an associate and later a partner for the firm MLT Aikens LLP out of Calgary, and have since relocated back to Saskatchewan. I've been working out at the Saskatoon MLT Aikens office now for approximately 18 months or so. And one of the areas that we're speaking on today is the United Nations Declaration on the Rights of Indigenous Peoples, which I've come to be familiar with, not necessarily in conjunction with the work I do with the firm MLT Aikens LLP, but more closely aligned with the mandate that I'm required to carry out as the president and board member of the Indigenous Bar Association in Canada, which is a national organization. It's not for profit, purporting to represent Indigenous lawyers, judges, scholars, students from across the country. And as an organization that has a distinct mandate for advancing the interests of Indigenous peoples and to ensure the evolution of laws respects the rights and interests of Indigenous peoples and governments across Canada, we were intimately involved with the drafting and critiquing Bill C-15. But not only that, I'd like to go a little bit back further to give some acknowledgement to some of our members on all sides of the political spectrum who critiqued Bill C-15, but ultimately drafted, had a hand in drafting the United Nations Declaration on the Rights of Indigenous Peoples itself, when they, some of our members, namely Willie Littlechild, had been working for years or decades internationally at the United Nations General Assembly to have this document drafted, supported, and then ultimately ratified. It's incredibly important to give a nod to those who had put years and years of work into the drafting of the bill, because I do think it's important once we start getting into the Canadian political context, how UNDRIP is now and has become very politicized, when the principles set out in that document are extraordinarily important. They're crucial for moving forward with reconciliation and the people who have put in the effort for decades to have that recognition or to have that protection of Indigenous rights recognized, I think it's extraordinarily important. So I'm going to give you just a couple thoughts on my perspective on UNDRIP and Bill C-15, which ultimately became an act to implement, or an act respecting the United Nations Declaration on the Rights of Indigenous Peoples. Now, where I came into this one, we were, as I indicated, we represent Indigenous, as the Indigenous Bar Association, we represent Indigenous lawyers from across the country, and not all of them share the same views. Actually, there are very disparate views when it comes to the approach regarding Indigenous self-determination and Indigenous legal rights. So when Bill C-15 was introduced, obviously it was a carry forward from a previous bill. The first iteration was a bill brought forward by Romeo Saganash that had died on the order papers, which hoped to implement or bring into force the United Nations Declaration on the Rights of Indigenous Peoples into where we are today, into Canadian law. And unfortunately, that bill didn't go forward, and it was resurrected under the guise of Bill C-15. And when that happened, when that discussion made its way into the public sphere, our members were all over the map in terms of whether they supported it, whether they vehemently opposed it. And unfortunately, I had members of not only the Indigenous Bar Association, but members of my family, Mary Ellen Terpel Lafond, a proponent on one side, Sharon Venn, a member of the Muskeg Lake Cree Nation, and I think a very vocal opponent to the bill on the other side. But those were two of the most vocal people in the two separate camps about whether they supported Bill C-15 or not. And as the IBA, we were essentially expected to come up with some coherent vision for whether we thought the bill was good in its current form, or whether we thought it could be improved, and what, at the end of the day, the United Nations Declaration on the Rights of Indigenous Peoples was intended to accomplish in Canada. And it was very contentious and politically controversial, but from my experience in connection with this, after having gone through not only the negotiation or the drafting of the bill, but seeing it go before the House of Commons and the Senate, and seeing the proposed amendments that were introduced in Parliament, and why they weren't adopted, why they may, or some of them that should have been adopted, is cause for reflection for me, certainly. And I think I was hoping to take a couple minutes today to pass that along to the group here. And I think why Bill C-15 struck such a nerve is because it's not only the bill itself, but the times we're in right now. I think we're in a very pivotal time in history. I think it's a crucial place to understand that we're seeing, I think, a clash between traditional legislative and legal principles and what Indigenous peoples view as being traditional legal principles. So on the one hand, you have our existing legislative framework, which has its genesis in colonial practices and assumptions about Indigenous people. Obviously, there was a subhuman characteristic to it, which we're beginning to learn more and more about now, about Indigenous peoples not having the ability to regulate their own affairs, about not being self-determining or self-governing entities, about not really being full and equal partners in the signing of the treaties. All of those were encapsulated in what we now know as the Indian Act and other colonial pieces of legislation and regulations that now that have governed the lives of Indigenous peoples day to day since. So that's, I mean, certainly a history that Indigenous people have and continue to live with, and that's the legal framework that we live inside. Now, Indigenous people themselves, particularly those who have carried forward traditions orally, believe that they practice a different law and adhere to a different law. And it finds expression in various languages and ceremonies, but for the most part, that Indigenous people are governed by, you could refer to it as natural law. A law that governs and is the common denominator for all living beings and the environment that we live in, and one in which no human being is above. And now, I don't want to give the suggestion that as Indigenous people, we're the only ones who believe in natural law. We're the only ones who believe in relationships with other human beings and the environment as superseding, that relationship superseding written documents, because ultimately, when things are reduced to writing, they lose that effect and they lose that ability to have that all-encompassing understanding. And I'd say, like, as tribal societies, we certainly are looking to reinvigorate those within our Indigenous communities. But in legal traditions, if you look back to the classics of writings of Cicero, I mean, going back over 2,000 years in the times of ancient Rome, there were discussions then. I mean, Cicero was writing about natural law and how, notwithstanding the fact that we have written legal documents which govern our day-to-day roles as members of society, there is this unassailable law that's real, and it's imposed on us by the environment in which we live in our relationships with other human beings. And what's right is right, and what's wrong is wrong. And so obviously we have that. And as a lawyer, and I hope a lot of people within the legal profession strive to do, is to ensure that those observations about what natural law is, about what occurs and what governs us as human beings, is reflected in the law, in the written law that governs us from time to time. And the problem that we're seeing right now, and why the clashes are coming forward, I don't necessarily think there's a disagreement about the fact that natural law needs to apply. It's the fact that the existing legal framework, insofar as it applies to Indigenous peoples, is vastly inconsistent with how Indigenous peoples view the natural law. And there's quite an argument to be made to support that. Now, like I said, I don't think there's a disagreement. As lawyers, we strive to make sure that the natural law, that the rights of people as they believe them to apply, and the societal and political movements which give rise to behaviors, are reflected in the laws. If the law isn't consistent with the behavior of its subjects, then it's bound to fail. It's bound to disintegrate. Where the disagreement came on I think in the case of Bill C-15, was the method for getting there, the method for creating a harmonization, or the process for creating a harmonization between natural law and the written law. And I say this, and I bring up the discussion regarding natural law because ultimately the United Nations Declaration on the Rights of Indigenous Peoples is an expression, that written expression, of giving space for Indigenous peoples to express what they believe to be natural law and to practice that in their day-to-day lives, as individuals, as collectives, as governing bodies. And that's it's such a long process to have the indigenous perspective, or the Indigenous view of natural law, brought into a public space. It was oppressed, and it was held back for so long that we're finally getting to a place right now where people with a voice are being heard, and they're given space. Now, the problem with the process, and I think the bill met with quite a bit of, and I'm not speaking to the opposition from different political parties outside of the Indigenous community. I'm just speaking strictly within the Indigenous community itself, was that many view the process under Bill C-15 as being too passive, as potentially being harmful to the implementation of and recognition of Indigenous rights and Indigenous natural laws. Whereas on the other side, those who view themselves as being more pragmatic or more practical, and seeing progress as being a very long, drawn-out evolutionary process. And there's a couple examples of this. When the political climate and the Liberal government certainly didn't help this out at all. This came on the heel, when the bill was introduced, it came on the heels of obviously Jody Wilson-Raybould's criticisms of the government. There's several other gestures of appeasement or tokenism that the government paraded around during this time. I mean, you look at the process that they had for appointing Indigenous judges, or wanting to appoint an Indigenous judge to the Supreme Court of Canada, the Child and Family Services action that they currently had going on, where speaking out of both sides of their mouth, they say on one hand that they support Indigenous children, they support Orange Shirt Day, yet on the other side, they're taking a decision, or they're challenging a decision which ultimately found that Indigenous children had been underfunded for decades. So there was certainly, the Liberal government certainly didn't have a lot in its corner when it introduced this bill, and they were already subject to criticisms of being proponents of tokenism, holding out certain examples as being tokens of progress, when realistically you peel back a couple of the layers and there was no intention to make any systemic change, no changes to the justice system, no changes to the courts, no changes to the way in which child and family services were being handled in substance. But in terms of superficial changes in recognition, Liberal government's extraordinarily good at parading that out. So when Bill C-15 was introduced, there were a lot of weaknesses in the bill, which the IBA had heavily criticized. I think they were very, very ambiguous and tricky around the language, where they talked about how the government intended to implement the United Nations Declaration on the Rights of Indigenous Peoples. When you compare the UNDRIP Act with other legislation that purports to incorporate or legalize or ratify international covenants in domestic Canadian law, the language is strikingly ambiguous, and the intention of the government can't really be, you can't really nail it down in this bill. And we had a lot of problems with the way that the bill was worded, because it left a lot of people, particularly those critics of the bill, with a lot of, it gave them a lot of fuel. It gave them a lot to work with in terms of criticizing it and making those arguments, saying, this isn't progress. This isn't real progress. We're not moving fast enough. We're not substantively doing anything to change the situation of Indigenous peoples in Canada. On the more radical side, and I think some of them have been accused, these proponents have been accused of being a little bit more fear-mongering, but some have indicated that the legislation was actually an attack on Indigenous rights, that it subjugated Indigenous rights and it made it subservient and subordinate to federal and provincial legislation. Now, I wouldn't go that far. I had plenty of discussions on this point with some of the critics of the bill, and I don't think I would go as far to say that it had that type of an impact on Indigenous rights and interests. But at the end of the day, the bill did end up going forward with very few amendments, notwithstanding the criticism that it had received. And we're in a place right now where it is legislation. The hope and the objective is that this becomes akin to the Canadian Human Rights Act, which will become part of our fabric. It'll be a quasi-constitutional document, one which is reflective of what all Canadians believe our approach is with respect to Indigenous rights. And I believe that to be, notwithstanding it's probably aspirational, and there's always a criticism that subsequent government can come in and repeal the act. We're all hopeful that it does have that long-lasting effect, and it does become part of a fundamental piece and a central law within Canada. Now, I won't go too much into what I see going forward, because I think the proof will be in the pudding about whether the government actually implements the principles of UNDRIP and takes a comprehensive review of the federal laws in place right now to ensure that they're consistent with UNDRIP. But the short-term value, and this is one we're going to have to wait to see if the courts leg onto, but the short-term value I see with UNDRIP is probably more in connection with current ambiguities in the law. And in my introduction, Jamie had indicated that I practice cannabis jurisdiction, cannabis regulation. When it comes to Indigenous regulation or governance over cannabis, the federal legislation is silent, as it is with respect to gaming under the criminal code. There is federal legislation respecting child and family services, but to the extent that there are any conflicts or inconsistencies with provincial or federal laws, the legislation doesn't go so far as to say which one prevails. But we're in a situation right now where we have Indigenous nations, groups, both regionally and nationally, who are looking to exercise jurisdiction over important matters that affect them on a day-to-day basis. And they're looking to exercise this jurisdiction over tobacco, cannabis, gaming, child family services. And if you interpret or apply that jurisdiction in a context or in a realm where UNDRIP governs and the principles of UNDRIP help to interpret and apply those laws, then I do think that we're going to be in a place where Indigenous nations will be in a much stronger position, and they'll be positioned to exercise and implement their own jurisdiction in whatever industry that they think that they have the strength and traditions and the capacity to do so. So that's optimistically where I hope to see UNDRIP go. In terms of the history of Bill C-15, obviously very contentious. Did it take us as far as we needed to go? I don't think it does. I think the wording could have been a lot stronger. In terms of the differences between Indigenous peoples, we're always going to have different opinions, and even UNDRIP, the Act, Bill C-15 itself, calls upon the federal government to recognize the different traditions of Indigenous peoples. But I don't think we're that far apart in terms of what we want substantively, but the process will always be a matter or a subject for further debate. So that's all I have, or those are my thoughts on Bill C-15 and UNDRIP.
Thank you, Drew. Dwight?
Okay, well, good afternoon, and thanks for having me. And I'm very pleased to be on the panel with my two co-panelists. I think we're each approaching this from slightly different angles in terms of what we're talking about, and hopefully those complement each other well, and we'll have a great discussion. I'm going to talk about some of the implications of the United Nations Declaration on the Rights of Indigenous Peoples Act, or UNDRIP, as a statute. So this is the statutory form of Bill C-15, which has become an act in the Statutes of Canada from 2021. I'm going to say a few things quickly on key contents of that act. I'm going to talk about some of its implications being broader than those that may have received the most discussion. And I'm going to talk about some of the very practical implications and ways that people from the legal community and other communities need to be engaging with this act and working together to realize upon its potential. So first, I'm going to talk about just quickly the key contents of this act. First of all, there's a preamble with a lot of symbolic statements. At a legal level, those may affect the interpretation of aspects of the act, but they don't have direct legal force in themselves. And so there was a lot of discussion about what should go in the preamble, and it's one of the longest preambles you'll see on any piece of legislation, but it does become mainly symbolic at the end of the day. Second, there's a Section 4 purposes clause, or a purposes clause in Section 4 of the Act. The purposes of this Act are to affirm the UNDRIP as universal human rights instrument, and to provide a framework for Canada's implementation of that. This section is a significant change from the predecessor form, Bill C-262, that's been mentioned before, because in Bill C-262, as a private member's bill, there was a section that simply set out to affirm the application of UNDRIP as an international human rights instrument, not saying that as a purpose, but making it an operative section. And it was with language not used before in Canadian statutes. And I think on Bill C-262, that generated some discussion. Bill C-15, or what's become the UN Declaration on the Rights of Indigenous Peoples Act, has put that section into a purposes clause, which could shape the interpretation of the Act, which marks a symbolic recognition of the role of UNDRIP, but doesn't have some of those effects that may be less certain in terms of judges being empowered to immediately start striking down pieces of legislation, as was one version of what could happen under Bill C-262's version on that, well-intentioned though the section always was. So that's a second piece here, is the purposes clause. A third piece is in Section 5 of the Act, which says that the Government of Canada is committed to all measures necessary to ensure that the laws of Canada are consistent with the Declaration. And so this is a very large commitment in some ways. I think it applies not just to future legislation, as some have suggested, but implies a review of current existing legislation as well. And there needs to be a process around that. And that this is an act that pushes Canada towards reforming a lot of the law that's there in Canadian law, and really removing paternalism towards Indigenous peoples, removing various forms of Canadian legislation that's been harming Indigenous peoples, for a very long period of time. And this is an opportunity to begin addressing that and having a process around reforming Canadian law. The fourth piece to the bill, or to the act now, is in section 6, which commits to an action plan to achieve the objectives of the declaration. That's phrased a little bit differently. It doesn't all have to be just about Canadian law. And in fact, lawyers, and I'm one of them, often think that we have expertise at things that we don't. Not everything about achieving reconciliation is about the law. Maybe actually a lot of it isn't about the law. And achieving the objectives of the UN Declaration on the Rights of Indigenous Peoples involves a lot more than law. And the action plan is an opportunity to put forth a lot of different policy initiatives to try to promote things beyond the law as well. So there's that commitment. In some ways, one form of critique of the act is that it slows things down, because nothing prohibited doing any of this before. Nothing prohibited doing this starting in 2015. Nothing prohibited starting doing this in 2006 under either of the, well, I guess 2007, I should say, after the declaration. Either of the recent governments could have taken these various steps, started working on the declaration in various ways. Now there's a 3-year timeline to develop an action plan to maybe start doing something down the road. That's the critique that some offer of the legislation. And there's some bite to that. But there is now this legislation in place where if there isn't action, there could be remedies for that. And I just emphasize that there's a statutory commitment there. There are statutory obligations there on the government. And to whatever extent they don't live up to them, people should be thinking about what remedies can be pursued based on the statute. The second piece that I'll mention very quickly is that the implications of this act are much broader than those that were sometimes discussed. Sometimes people talked about the declaration in some of the media discussions around this, the bill, as if it were just about free, prior, and informed consent. And that's an important piece to the UN Declaration. But as other speakers in this series have highlighted, there are a lot of other components to UNDRIP. The right of self-determination, participatory rights that aren't just about FPIC, but could be framed a bit more broadly than that. Land rights, various cultural rights, rights in whole areas of human rights as distinctly applied in the context of the circumstances of Indigenous peoples. All of those are in UNDRIP, and this legislation commits Canada in relation to all of those. So just trying to wrap up quickly, what are some practical implications that we should highlight? One of those is that there's much more significance to international law than may have sometimes been realized in various constituencies. Law students should be studying international law in order to engage with documents like UNDRIP, because they're going to have a profound practical significance directly within Canadian law. And it's not the only instrument along these lines, but it's the one we're talking about today. And so I just say, even business needs to be informed by international law in a way that maybe wasn't realized before. Those in potentially affected sectors need to be seeking appropriate legal advice around the implications of this act. There could be immediate or relatively immediate effects if anyone litigates based on the legislation, as has happened with the BC legislation. I'm not sure that they can be successful with it, and some of the attempts under the BC legislation didn't go anywhere in the immediate term, but in the longer term, there can be litigation based on it, and certainly longer term, there are implications from the act, as well as the chance perhaps to offer commentary within the development of the action plan from various sectors that are affected. Everyone needs to be seeking the appropriate legal advice for whatever context they work in, whether that's in an Indigenous government who are going to be affected, or whether that's in various sectors of industry, or whether that's in other governments. And everyone needs to be ready to really be focused on Indigenous issues in the coming years, to really work together to achieve some of the potential of this legislation in constructive ways that set out good policy for the future that brings everyone together. And people like Sandra Cotter better be planning a lot of agenda space for the changes that need to come. There's a lot of work ahead. And I just say that's the main conclusion, is that there's been this statute adopted. That's not the end of the road. It's just the beginning.
Thank you, Dwight. Corin?
Hello, everybody. My computer just crashed, so we're gonna wing this. Thank you, everybody, for having me. My name is Corin Lightning Earl, and I am from Treaty 6 Territory. I'm from Samson Cree Nation, and I'm a lawyer here at Makoto and Land Governance Lodge at University of Alberta. Thank you, Drew and Dwight, for your comments. I was reflecting on what to say today in terms of how do we start to have a discussion. I think Drew and Dwight have really created that foundational piece in terms of some of the things to think about, how the law came to be, and then also thinking about how I was listening to Romeo Saganish and Brenda Gunn about really the basics of UNDRIP and is UNDRIP and its implementation with the new bill. Is it going to be reconciliation, and how does that kind of play forward? So I think about my role at Makoto and Land Governance Lodge, and the lodge was created out of call to action number 50, which called for the federal government to support the creation of Indigenous law institutes and research units to be created to support the revitalization of Indigenous laws, and so that we could work with communities to support that in a way that they haven't been supported before. So that's kind of what we do here, is we work with communities that they are the knowledge holders and the wisdom keepers of their laws. They know their laws. They are not written, but they know them. They've lived them. They pass them down, and they have all of the knowledge. So how do we support them in not even necessarily revitalizing, but it's just capturing it in a way to support them to move forward? And sometimes because of colonization and residential schools, a lot of communities have had a lot of setbacks. So they're just trying to figure out, well, what are our principles and values around, say, child welfare? What are our principles around values around sentencing? And really going back to kind of looking at that traditional knowledge. And right now, COVID has taken, when I think about moving this forward and working forward with communities, is COVID has taken a lot from our communities right now. And a lot of our elders in our communities are, and knowledge keepers have been affected by COVID. So it's really important to start supporting those communities sooner than later. And how do we kind of build that? And so lots of the times when the laws come into play, here's a law and go forth and let's figure out how to do this. And so I think about the funding and the capacity of people to kind of do this. So it's like everyone needs to start talking and focusing on Indigenous issues. And so my concern there is, I think that's a great thing. We've been doing that bits and pieces here and there, but do we have the capacity to understand Indigenous issues? Most law societies are just implementing their first wave of Indigenous awareness and cultural training, and it's very much at a grade 8 social levels for some of them. And it's just introducing the idea of Indigenous peoples as humans, and how do we rehumanize Indigenous peoples? And so although we need to be aware and have those conversations about Indigenous issues and get ready to start to re-examine our laws through the eyes of UNDRIP, is we need to ensure that we have the education level prepared for those that are going to be doing the examining of those laws and the rewriting of those laws and the commentary on those laws. Because sometimes what underlies beneath the surface is that idea of unconscious bias. And so we want to ensure that the interpretation of how the implementation of UNDRIP is not weighed down by the unconscious bias of people doing that interpretation, whether they're working in the federal government or in other agencies, and ensuring that it has the true spirit and intent of UNDRIP. And sometimes we forget that. We're like, yes, we need to do all this work, but are those people educated to do the work? Do they know about unconscious bias and discrimination in their work they're doing? When I think about Call to Action 42, it does talk about the recognition and implementation of a justice system consistent with Treaty, Aboriginal rights, and the Constitution, and UNDRIP. And so with the work of the Lodge, being able to move that forward and work with communities for them to decide on their own, to really create their own mechanisms of knowing and interpreting law on their own. So that kind of provides them that opportunity to be seen and heard in the law and kind of create that equality. And I know some of the concerns about the bill coming into force is there's a lot of confusion about how do we implement this? What does this mean? And so, and for some, sometimes you get pretty apprehensive. But when I did meet with some industry, and we've just kind of broke it down, and it's really about if we look at it as something that concerns us, then we start to look at all the negatives. Well, is it privileges? Who's losing privileges? Who gains? Is it rights plus? Is there a veto card? And all of these things. And so really it's not, it's just really about elevating up Indigenous people's voice, which should have been done a long time ago if we really started to look at those TRC calls to action. This is just one step. It's not the all answer to reconciliation, but it's one step in terms of getting towards that. And I think it's a significant step because it does create measures and opportunities that we think of and we know that should be there, but it does kind of create that accountability. And so in the review of these laws, and we think about, okay, everything has to be relooked at in the eyes of UNDRIP. So in 3 years, we have to create this action plan and we have to review all the laws in terms of UNDRIP. Well, there's a lot of laws. I'm sure we could all think of a law that is a little bit not in line with UNDRIP, to say it a nice way. Let's just talk about membership under the Indian Act. And that's a whole time. So I'm really excited for people going into their masters and PhDs to start writing and interpreting which laws need to be updated. Is our constitution need to be updated? Is that in line with UNDRIP? That's a conversation we could also be having. But it's also a scary conversation at the same time. But I think it's really, if we look at the bill as an opportunity to relationship build, to really do some relationship build, because it doesn't just say consult, it says cooperation. And so when we look at relationship building, it's a two-way street. So it's not here, we consulted, pass, keep going. No, there has to be an opportunity of relationship and cooperation from both parties. So I think it's an opportunity for people to really have that conversation and that dialogue about what does this look like for Indigenous communities? Because we're going to need everybody's heads at the table. We're going to need everyone at the table that has the knowledge, that has the passion, that has the expertise in this area to come forward. And we're also going to need some clear understanding of what this means for people. Clear understanding all the way from politicians to educators to grassroots peoples to people in high schools. And what does this mean? So really creating that clear education in terms of how are we going to move this forward? How is Canada really going to create that turning point? Because it is really an opportunity for change and opportunity for growth. So I think those are the things that excite me. And those are some of the things that I think we do need to talk about is how is this going to all happen? It's the who's and the what's and the where's and the why's. And where's that funding going to come from? And that, I think those are practical concerns and real concerns, but I think it's also an opportunity to really work together and really create that space. And if we think about it, if we look at it, it's not about taking away rights from somebody else, but it's about elevating Indigenous peoples and their voices to what should have been some time ago. And just acknowledging those. So I think there's some real conversations that'll be have to had. And there's going to have to be more opportunities and spaces. So I'm excited about it. And again, as a lawyer, we all have our concerns about the legal background and the know-how of how is this all going to work out. But then also as a researcher and someone working with Indigenous communities, how is this going to play out for Indigenous communities moving forward, even in the creation of their own laws? And how does that work forward? The ideas of bylaws and Indian Act bylaws and moving forward. So we're kind of starting to see that now with Bill 792 and how that's playing out. So, but it'll be interesting. So thank you. And I'm looking forward to answering some questions.
Thank you. At this time, there isn't questions within the chat. However, I know that as the speakers committee, we have, like I said, come up with a few questions for prompts. I think it's great, though, that some of you guys have already answered them with regards to even one of the questions was like within the Indigenous community about the excitement or optimism about this becoming law. I think we heard that in Corin's and in Drew's explanations so far. But I know that one of the questions here is how do you how do you see this being brought up in an argument for infringement of Indigenous rights? And like whether or not, like how much of effect this might have with Indigenous rights or Aboriginal rights, especially underneath section, with regards to section 35 and the use of UNDRIP. I know that this is still very new, but if anybody has anything to weigh in on that.
I can jump in. Sure.
Okay.
I'll just say, I mean, obviously as a statute doesn't change the Constitution. And so at one legal level, it doesn't have that directive in effect. But I think the affirmation of the UN Declaration on the Rights of Indigenous Peoples contained in the statute involves a bit of an invitation to judges to think about the role of UNDRIP anew. And there are judges who've engaged with it to some extent, but there are others who've not. And the Supreme Court of Canada certainly has scrupulously avoided citing to UNDRIP in a number of cases where it's been argued before them in recent years. But we could yet see that change. And certainly there are parts of UNDRIP that are customary international law apart from the statute. And in theory, that becomes part of Canadian common law. And there's case law to that effect. But I guess just in general terms, we've seen some courts reluctant to do that. And I think the statute may be a bit of an invitation to them to engage more with UNDRIP than they have done so far. But there might be other perspectives on this within the panel, and I'm keen to learn from everyone.
Corinne or Drew, do you have anything to add to that aspect?
I agree. I think it's an opportunity for judges to really look at what because as Indigenous nations grow, they're going to be creating their own mechanisms for how they're going to hear matters in their own communities. So it'll be interesting to see how that plays and the weight that the court gives to those, and they should be giving to those their own dispute resolution mechanisms. And if we see a growth in those, will we see a decline in negative judgments, or will we see people starting to move forward? As we're seeing in a lot of communities, and even in non-Indigenous communities, the establishment of courts specific for Indigenous peoples, mainly when it comes to kind of those criminal matters or family matters. And so interesting to see where the federal court takes this in their interpretation of things like election laws and tribunals and those types of things.
And so I think what to build off of Corin and Dwight's comments, Dwight's absolutely right. There's the rights that we're talking about are Indigenous rights. Those are inherent rights, which stem from the preoccupation of Canada by Indigenous peoples. Those are recognized and affirmed under the Constitution, federal legislation. If it were to purport to have any infringement or extinguishment of those rights, has to be clear and unequivocal. And in this case, there's absolutely nothing that comes remotely close to that. On the contrary, there is express non-derogation language within the statute itself, which I would use that as a mechanism to call into question any criticism that this bill has the effect of legally impairing or infringing upon or lessening or weakening Indigenous rights. Now, the political argument was made that Indigenous rights are rights that are exercised by Indigenous governing bodies themselves, and they don't require validation from the federal government or the provincial government. You don't need a federal statute in order to recognize or give effect to your Indigenous laws. Point taken. However, there are Canadian courts, federal legislatures, federal decision-making bodies and tribunals, all of whom are currently operating under a legal framework, or prior to Bill C-15, were operating without any reference to UNDRIP. And if they were made in passing. If the courts were rendering decisions, they were doing so in a manner that was purely an obiter. So there is a Canadian framework which exists and operates parallel to Indigenous laws and Indigenous jurisdiction, and to have recognition and the space created within that federal sphere only helps the harmonization of the two laws and helps the two laws to work together. And more importantly, in the event of a conflict or an inconsistency between the two laws, helps to adjudicate those conflicts. And that's one of the things that we had taken, the IBA had taken into account when we wanted to make several changes to the bill to just to clarify that UNDRIP is being implemented into Canadian law. And that was to draw a distinction between Canadian law, which was referring to federal statutes and regulations, and Indigenous law, which is a law that was maintained and espoused by Indigenous nations themselves and expressed through Indigenous governing bodies. Unfortunately, that amendment wasn't introduced and didn't make its way into the bill. So we'll continue to push for something like that, just to give clarity to what I explained earlier. The federal statute simply cannot infringe upon, in the way that it's currently worded, infringe upon any Indigenous rights or jurisdiction.
Thank you, Drew. I know that W. Dale just wanted to clarify with the mention of bias that Corin was talking about. They had heard uncultural, but it's the unconscious bias that you were speaking about, Corin. Did you want to just give a brief example or information about what that is for those that might not know what that means?
So unconscious bias is just a bias that people hold towards people that are different than them and usually of another race, class, or culture. And people are like, well, it's unconscious. How do you know? So what it sometimes just, it's kind of displayed in small, subtle ways when they're working with other people or working for other people or possibly working on documents for them. And so sometimes I see it in, for example, if I'm in a room with child welfare people and we're talking about Indigenous communities and laws, there's lots of othering, well, they and them, and really othering people, othering Indigenous peoples and speaking in a manner where Indigenous peoples are less than. And this is the same room of people that may be deciding on funding for this nation. So they already have that acting on an unconscious bias by othering them and lessening them. And so those are the things that we need to think about in terms of who is doing this work, and ensuring that they have the education, but also have the cultural awareness and are not discriminatory or have unconscious bias themselves when they're going through these provisions.
Okay, thank you, Corin. I know that we have another question, which was about when we did. I know so far we've talked about the jurisdiction between Indigenous laws and then of course Canadian laws, but we've been focusing right now on the federal aspect. And one of the questions that has come forward is how crucial is it that provincial governments with a wide range of jurisdiction over matters that are also critical to the future of Indigenous people and their governments embrace UNDRIP and participate in this process? Right, because we know that British Columbia has implemented on a provincial, or has passed a law on a provincial level to implement the UNDRIP principles. However, the other provinces, as far as I know, have not. So anybody have any ideas about how, like I said, like it says here, how crucial it would be whether and how the provincial governments might come on board with putting forward the UNDRIP principles themselves? Because, right, okay, good. Yeah, Dwight, I was gonna.
Sorry, I just didn't want to jump in if someone else wanted to go first, but I'll just say quickly, it is crucial that provinces be involved because in a federal state, certainly jurisdiction over a lot of things that has real effects is at the provincial level. Although there's a special federal relationship with Indigenous peoples constitutionally, partly contained within Section 9124 of the Constitution Act 1867, and partly in a variety of relationships over time, there's still a lot of ways that provincial governments have effects. And so in British Columbia, there's a statute. Provinces that don't have statutes aren't barred from taking action either. And so I hope that even those that haven't gone the route of statutes will be engaged in various processes to work together with everyone and find good paths forward. I'd just say there's an unfortunate dimension to the discussions around Bill C-15 that it actually drew a letter expressing concern from a number of the premiers and wanting more time to think about it. And of course, there's an urgency to things at the same time. And there's time that people need to work through things. And so some of the premiers in that letter expressed that they wanted that time, and the federal government didn't want to slow things down, understandably. So there's a need to get those premiers on board in working in good, constructive ways. And I think that there's a really important task for everyone in trying to reach across partisan divides and not see UNDRIP as about something of one party or another, but to see it as something that everyone can work on together. And I love a lot of the points that both Drew and Corin made, but just I do have to highlight, I agree entirely with this point that the education level is a challenge in terms of everyone getting together and working on Indigenous issues. And so there's a lot of work that needs to be done on that front in terms of not just lawyers, but others in terms of getting people up to some level where there can be a sensible, informed discussion that isn't shaped by stereotypes and so forth. And we've got a lot of challenging tasks ahead, but we need to overcome divides, not create divides.
Thank you, Dwight. Corin or Drew, did you have anything to comment on this one? So this will be our last question before we wrap up.
Sure. There's only two comments I'll pass along to this one, and it's for those critics who, for the same reason, had said we don't need the federal government to validate or give credence to any of our Indigenous laws for them to be enforceable. Again, of course that's correct and that's accurate. But those same critics said even more so, what role does the provincial government have, if any, in the recognition of Indigenous rights? A lot of First Nations and Indigenous groups view their relationship with the Crown as being a relationship exclusively with the federal Crown, to which the provincial government's either a fly on the wall or a stranger and has no role or involvement in that relationship. If it's a Crown Indigenous question, that's a government to government question, and that's something that needs to be played out with the federal government. And that seems to be the sentiment that we had received when negotiating or consulting with our various members across the country. Now, legally, and from a practical standpoint, as a practicing lawyer, I think it's, to Dwight's point, incredibly important because, as I indicated earlier, I think that Indigenous laws operate parallel to various other orders of government, and they have to interact and correspond with them. And when there's a inconsistency or a conflict between Indigenous law and federal or provincial law, we'll have to figure out how we adjudicate those. So I think it's incredibly important because the province has a wide scope of jurisdiction under its umbrella, which includes things really important subject matters, civil and property rights, things such as commercial disputes, regulating environmental management within the province, regulating certain things which could potentially impact the exercise of treaty rights. These are all things which, again, the Indigenous law operating in parallel with the two other orders of government is incredibly important. And the political reality is I don't think that we're going to be within a country mile of getting there in at least Alberta, Saskatchewan, Manitoba, and I think Quebec obviously just challenged the federal Child and Family Services legislation as being ultra vires the feds. So I think particularly those four provinces are pretty far from getting to a place where they're going to be adopting UNDRIP. But hopefully, and hopefully not in the far distant future, education and partnerships we're able to use those mechanisms to try to build an understanding that's mutual and to try and ensure we get things like a provincial bill recognizing and implementing UNDRIP in place.
Thank you, Drew. I was like, Corin, did you want to speak? I know that we're not giving you much time before we wrap up.
No, it's okay. I think it is important. I think we're far past the time where it gets to be an option. And I'm surprised Alberta didn't put it on their ballot for today. Should we adopt UNDRIP? Because we're talking about equalization payments and daylight savings now, but I think it's the leadership needs to start taking a stance, because it does, as someone living in an urban setting, and it sure would make life nicer if we could just get these things done. And I think it's there's so many different agendas between the political, the province, and the feds, and whose voice is bigger than the other. So I think it's just time where we're past should we not implement UNDRIP? Like that, if we're still having that conversation, we're just kind of missing that boat. So now it's like, how do we move forward with UNDRIP and everybody together? Otherwise, we'll just continue to run in circles. Thank you.
Okay, thank you. I'd like to thank Corin, Drew, and Dwight for joining us on this panel. And as well, I'd like to thank the audience. I believe, Brent, were you going to just wrap up with thanking our sponsors, or is that my job?
I'm happy to do that,
Okay,
Jamie. Thanks.
Thank you.
So if I may, thank you to the presenters. That was terrific, and their responses to the questions. And thank you to the audience as well, as Jamie mentioned. This doesn't mean anything without you. And a thank you to McKerchers once again for their support and sponsorship of this whole project. We will be conducting another Speakers Committee session next Tuesday. I hope you will look in. It relates significantly to the impact of COVID and on a whole series of matters related to law and access to justice. And the series will continue into November. Thanks once again for joining us and taking time out of your day and your lunch hour to participate in this very important session. All the best today and for the balance of your week. Thanks.